The first one is by Gregor Lienemann online because he's in their quarantine from the University of Passau. So Gregor, you have about 20 minutes, 25 minutes for presentation, and then Juan will discuss your paper and we open it for questions, and then you get to respond. So please, who shares the slides?
I can share them myself, I think.
Okay.
You should be able to see. Thank you, Professor Finger, for the introductory remarks, and thank you for the FSR conference team for giving me the opportunity to present remotely. My co-authors and I would, of course, have loved to attend the event at the conference venue in Florence, but this has not been possible. Nonetheless, we hope to enrich the interdisciplinary debate of this conference from a legal perspective. I've seen that there's already been a talk on data cooperatives this morning, I think, and my talk will build on that from a different angle and look at another novelty introduced by the Data Governance Act of the European Union, namely on data intermediaries. The topic itself could not be more current. Could in fact not be more current because the DGA was just published last week in the European Union official journal as Regulation 2022/868. This is remarkable because the DGA marks the first item on the European data strategy to enter into force after merely 1.5 years. As is common with European legislation, there is a grace period for the new legislation to apply. Generally, this will be 15 months. So the 24th of September 2023 will be the compliance date. But with the topic of this talk, data intermediaries, the compliance period extends to 39 months until 24th September 2025, which just goes to show that the legislator recognizes a greater effort required for data intermediaries to adapt their businesses to comply with the new regulation. Before I go into detail about the regulation of data intermediaries, I would briefly like to sketch what else the Data Governance Act has in store. It pursues a kind of piecemeal or disparate regulatory approach in its chapters 2 through 9, from the public and private sectors, from obligations to enforcement to technical implementation. Chapter 2 is then concerned with public sector held data and the reuse of that data under certain conditions. Similarly, chapter 4, data altruism organizations, is concerned with open data in a broader sense and reusing certain valuable data for research purposes. So those two chapters may well act together. Then there's a common complaints and remedies framework, and the DGA introduces a new regulatory board, the European Data Innovation Board, under Articles 29 and 30, which will be comprised of members of, for example, the European Data Protection Board and the European Commission. Finally, for all of these chapters, the DGA has some technical safeguards that have to be met under Article 31. This can broadly be compared to what the GDPR prescribes under Article 44 following for data transfers of personal data. Here, non-personal data are at issue. Reverting back to data intermediaries, the Commission sees them as an avenue to promote fruitful data sharing between businesses, i.e. on a B2B level. Currently, such data sharing occurs at a relatively low volume and between few participants on any given market. This likely is due to fear of competitive disadvantages when sharing one's data. And these factors in turn influence some barriers that still persist and therefore obstruct seamless data exchanges. First, there are information asymmetries at all stages of the data transaction. So often businesses will not know where to find the data sets that they are looking for, and where they find them, it will be difficult to agree on pricing because of limited experiences in these matters. The contract to conclude it is difficult because data licensing agreements are not yet formally understood. And also the monitoring of said agreement can in turn drive up transaction costs. Furthermore, technical hurdles need to be overcome, most notably the interoperability between data sets, meaning that the data given by the data holder and by the data user and extracted by the data user can be used on the respective IT infrastructure. Finally, there's a complex web of legal requirements, not only by the DGA, but also notably by the GDPR. The GDPR only applies to personal data. However, its ambit is relatively wide because even data that may at first glance seem purely non-personal, industrial data, can turn out to be personal data when they are rearranged and recombined with other data sets. All in all, this leads to the problem of very high transaction costs for B2B data sharing. The European Commission then thinks that data intermediaries can do away with part of these obstacles. This is due to the fact that intermediaries in general can obtain a so-called matching position between the suppliers of a good and the buyers, the acquirers thereof. In that sense, any two-sided online platform is a data intermediary. Platforms such as Uber, Airbnb, Amazon Marketplace have been described as such, but this is a non-technical sense of the word, because these platforms have further service goals in mind and not just the intermediation and the trade of the data themselves. What data intermediaries can also accomplish is the standardization of data transactions. So to achieve some level of consistency for the data trade that emerges, for example, through contact templates or by having standardized data formats and conversion techniques in hand. Finally, supplementary services may be offered by data intermediaries, for example, the anonymization of data sets for their customers. Why does the European Commission then see the need to regulate data intermediaries, which are, as I will point out briefly, an emerging phenomenon and relatively new on the market? Well, the European Commission observes a lack of trust in these intermediaries, or more specifically, a gap between the actual user uptake and the potential user uptake. According to a study by the European, 60% of respondents would rely on data intermediaries if they were trustworthy and operated in their field. So that is one of the reasons why the Commission wants to step in here. The other one being that it fears the entry of powerful market participants, such as gatekeepers under the Digital Markets Act or other powerful GAFA player, which would move startups, smaller firms, medium-sized firms to the fringe of competition. With this policy background in mind, I would like to turn to the legal definition of what constitutes a data intermediary under the DGA, Article 12.11. Data intermediation service means a service which aims to establish commercial relationships for the purpose of data sharing between an undetermined number of data subjects and data holders on the one hand and data users on the other, through technical legal, or other means. What this means is first, the establishment of a direct commercial relationship excludes so-called data brokers, which do not operate directly between data holder and data users, but enrich and aggregate data they have obtained from data holders for data users. This is a key exemption of the Data Governance Act. On the other hand, the requirement that the mediation has to occur between an undetermined number of data subjects and so on means that closed data pools, i.e. such for a limited number of participants that is predetermined, or platforms that are only used by a single market entity, will not fall under the regulation. An example for the latter would be BMW's car data platform, which operates exclusively for vehicle data for that car manufacturer. What then is covered by Article 211 and the according definition there? Well, there are two basic business models for data intermediaries. First, data marketplaces, where data holders can put their data up for sale, which can then be acquired, or rather be licensed to data holders, and the data intermediary earns a commission on those purchases. An example would be the data marketplace here, where data measured by IoT sensors or in connected cars can be traded, for example, between a car manufacturer and a company producing navigation systems. The other type of business model covered by the DGA is an open data pool, i.e. a data pool which is not set for a specific number of participants, and which is open under fair, reasonable conditions. This works in such a way that data holders have to disclose their data in order to gain broader access to the data within the data pool. An example here would be Airbus's Skywise platform for aviation data, which is used as a way of exchange between airlines of various kinds. If a provider meets these classifications as either a data marketplace or an open data pool, then they will have to comply with an abundance of requirements under Article 12 DGA, namely 15 such requirements. My co-authors and I have tried to group them into three categories. The first category being neutrality and purpose limitation. This is underpinned by the European Commission's idea that data intermediaries are a neutral entity between the data holder and the data user, which may not act partial to either party in this transaction. First, a structural separation of the data intermediation service from other undertakings must be achieved. This means that there has to be a separate legal person with a separate headquarters, etc., for the data intermediation service. It does not mean that no affiliation to a corporate group may exist for the data intermediation service. To ensure neutrality, the data intermediation service may also not use the data they obtain and mediate for any other purposes than to share the data onwards with the data user, or to develop its own service that accomplishes this feat. The exception here are the supplementary services, which I've touched upon earlier, i.e. those regarding conversion and anonymization, but also those feed into the broader goal of making data sharing more appealing and more trustworthy. The second requirement or the second set of requirements, concerns the overall fairness of the data intermediation service when providing its services. Here we find some competition law-like prohibitions. For example, in Article 12.b, a general prohibition on bundling and tying. This is a classical vertical restriction under competition law, meaning that this provision of one service, here the data intermediation service, may not be made conditional or linked to another service that data users or data holders also have to use. An example here could be the use of a specific software, browser, program, whatever, to access the data intermediation service, the platform offered by the DI. Along these lines, there is also something familiar to competition lawyers, namely FRAND standards that have to be adhered to by the data intermediation service. FRAND means here fair, reasonable, and non-discriminatory standards for accessing the data intermediation service. This entails disclosing the terms of service and especially the pricing calculation for accessing the platform. This displays a close interrelationship with the new Data Act, by the way, because in Article 8 following, there are detailed conditions on what should be considered FRAND standards in the ambit of data licensing. Finally, from a user standpoint, the data intermediation service has to ensure a continuity of its service, even if they become insolvent. This means that there have to be mechanisms in place to allow the retrieval and the onwards transfer of data. Such a remedy resembles concomitant legislation in Article 20 GDPR, for example, the right to data portability, or Article 16, Section 4 of the Digital Content Directive for retrieving digital content. Finally, the DGA makes clear that a lot of technical safeguards have to be put in place for data intermediation services to operate on the market. This concerns primarily the condition of interoperability first between the formats offered by the data holder and the data user. Conversion into an interoperable format in this case only has to occur upon request by the user, by the data user, or where this is required by law. Here again, the Data Act might come into play. And more crucially, between data intermediation services themselves, there has to be a level of interoperability by default according to the open standards for interoperability, which will have to be developed, e.g. by the European Data Innovation Board. And then there's a variety of measures against unauthorized and unlawful access. Most notably, providers have to inform data holders and data users in the event of a breach and have to observe special safeguards when processing data protected by trade secrets or by copyright, or which are otherwise competitively sensitive. Having seen these requirements, the question arises whether they actually support the role envisioned by the Commission for data intermediaries in the European data economy. My co-authors and I have three major quibbles with these requirements and the associated goals. First, an empirical problem. The European Commission seems to base its concern for data intermediaries on this lack of trust narrative, which appears a bit monistic from our viewpoint, the other barriers to low data sharing might in fact be more prominent, such as the complex legal framework, the technical obstacles, and so on, which I have sketched earlier. Secondly, compliance cost will pile up under this new method. There are notification and monitoring procedures which will put administrative burdens, especially on smaller firms that are not equipped to deal with these administrative matters as well as larger incumbents or firms. And when it comes to stacking on top the obligations, a provider will likely have to meet both the requirements under the GDPR and under the Data Governance Act, making the obligations come up to almost 50 different requirements. Finally, and most importantly, the European Commission finds itself in the so-called Collingridge dilemma for technological assessment after David Collingridge. This means that there's now a situation which might develop into a certain direction. The Commission thinks that dominant entities will go into the market of data intermediation services and tip it in their favor. This is unclear at this point, but if nothing is done about it now from an ex-ante viewpoint, then ex post, it might be too late to step in because of irreversible and entrenched market developments. This is the Collingridge dilemma in a nutshell. The European Commission has chosen to take the ex-ante route. Whether that will be the right route is not yet clear. Let me make
Gregor, can you conclude, please? You have taken 20 minutes already.
Okay, yeah. Let me make one final point. The European data spaces are not mentioned a lot in the DGA, and also in the health data space proposal, the DGA vice versa isn't mentioned. So there's a lack of clarity between these two instruments, the data spaces and the DGA. And it will be interesting to see how this develops for the classical network industries such as mobility and energy. That's it for me. Thank you for your attention.
Thank you. Juan.
Okay, thank you. Well, first of all, I have to say that I've learned a lot with the paper. I think you managed, I mean, the paper is long, it's 40 pages, but you managed to introduce not only a description. I have to say, the paper, I would say it's richer than the presentation. I think the presentation you focused, Thomas, on the kind of description of the legislation, of the piece of legislation, while the paper is much richer than that. It is successful in explaining the different types of interaction around intermediaries, the different tensions, the different pieces of legislation, competition law, GDPR, IP rights that have an impact. So in that sense, I have to say the paper is very good in taking all the pieces into consideration. Now, I'm definitely, it's, yeah, you were introducing it at the beginning. No, it's, don't introduce it. It was wrong. Sorry. So, yeah, it's, I mean, it cannot be more timely. I mean, it was just, the final version was published. So, so it's right on time. And definitely the paper is a very good way to analyze the piece of legislation. Then I have, yeah, some comments to make. Some of them are more formal, some of them are more on the substance. On the form and in terms of publication of the paper, it is too long and the structure is too complex. You have, I don't know how many headings, subheadings, subheadings. I mean, it gets very confusing and you provide very little help to the reader in terms of an introduction explaining the kind of, I mean, section 1 is devoted to this, section 2 to the other thing. It's quite complex to navigate through the paper without this help with such a complex structure. And somehow I have to say, I mean, you devote 21 pages to the introduction, which I found very, very informative, but maybe it's not the key element for a paper. And then it's only in page 22 that you really start with a piece of legislation. But this, I mean, formalities, it depends on how you want to frame your work. I mean, it's not so relevant at the end of the day. But I have a more fundamental comment. Basically, you introduced the doubt about, first of all, you claim that these regulatory obligations on the intermediaries are rather exceptional. If I remember correctly, you introduced that, you used that word. And then you say that it might be an obstacle to innovation and really to the development of these intermediaries. I don't quite agree on this element that this kind of regulation, of such a detailed regulation is rather exceptional. I think, on the contrary, that this kind of regulation is very common around intermediaries. And I can just, it comes to my mind a number of precedents of examples which are quite similar to this kind of regulation in traditional intermediaries. And I'm going to give you just one example, which is stock exchanges. So complex, sophisticated marketplaces, and the stock exchange probably is the most sophisticated, and it has a long history. I mean, you could identify even in medieval marketplaces, you already had a lot of these elements to create trust. So sometimes, I don't know if you come from the competition law world, where competition lawyers very often try to have this tendency to think that one piece of legislation solves all the problems. But there is a lot of tradition in the regulation of intermediaries, marketplaces, stock exchanges, of these very similar obligations to create trust. And you have even a lot of codes of conduct, and just one, even the most basic one, on the code of conduct of real estate agents in the United States has a lot of these elements included. It's not a piece of regulation, it's just a code of conduct of an association. But the fact that intermediaries are always suspected, that they have structural conflicts of interest, and that you want to create trust, and that regulation is a way to create this trust is not exceptional at all. There are lots of precedents. Sometimes it's not necessary, but when you get to very sophisticated markets, again, the stock exchange, all this structural separation, this transparency, lots of these elements are in that in those pieces of regulation. So I would say it's not surprising to me, a lot of the elements that I see in that regulation. Now, is it really necessary? And then I come closer to your position. It seems to me that it is a little bit early, I mean, to introduce such a complete set of obligations on intermediaries that really are just emerging, starting to grow. And we don't really know, even if we will have something similar to kind of an stock exchange. So if we will really have marketplaces of data around the industries. So I think, so I'm sympathetic to this distrust that you have to this commission, or I think that it's not a commission proposal at this stage, it's a piece of legislation by the EU institutions. So I'm sympathetic to the idea that not so much that it is exceptional, that maybe it's too early to go for such a complete set of obligations. But then I have this, this idea. Here in Florence, we met very often with industry players. I mean, we have seen, particularly in transport, we have seen it in aviation, we have seen it in railways, we have seen it in urban, we have seen the ecosystems, we have seen the companies together claiming to have an alternative to the gatekeepers, the Silicon Valley, and that they wanted to create something different with more control, an alternative way to digitalize. And so we've heard many times that we need governance, that we need trust. I mean, and we see it across at least all the transport industries. And I think it will be pretty much the same in all the industries that start talking about data sharing, how we do it. We need common infrastructure, we need standards, we need interoperability, we need at the end data sharing, and we need trust. So I'm sympathetic to the Commission position of, okay, maybe we need to step in and create that trust. And really, I think it depends on the perspective. If you just start from you have the alternatives are a complete set of regulation like the one we have in the DGA, or the alternative basically is nothing and let just the market grow and create these ecosystems. Yeah, one might wonder, well, maybe it's too early, let's wait. But in my view, the position of the European Union, particularly the Commission, was not so much about let's regulate this way or just let the market. The alternatives really were, we already have the gatekeepers. We have to develop an alternative form of digitalization and for data sharing and for the creation of the ecosystems based on data. And we have to hurry up because the gatekeepers are already there. So we cannot just wait because we are getting it from the different industries that if we do nothing, these alternative ecosystems, more horizontal, not depending on the Silicon Valley platform, they just don't emerge. They are not emerging. There is too much distrust. So we need to hurry up. Now, my final question is it enough just to adopt these pieces of legislation for it to happen? I am very suspicious. Well, probably they help, but we will see over time whether this very complete set of obligations. And again, most of them I think make sense. I mean, and you will find precedents in a lot of traditional intermediary regulation. But I come closer to your positions. Maybe it's not mature enough. Maybe instead of providing a very trustful framework for everyone to share the data, maybe they are just making it even more difficult for the intermediaries to step in and really help the different industries to digitalize and share their data. And just one final comment. You were referring, and in the paper you underline a lot, that there are a lot of loopholes. So the brokers, there are different loopholes. Maybe it's made on purpose because the Commission is not so, they don't really have the ambition to regulate everything, which is somehow, it's just that they are trying to provide one solution for those that want to use it. And the loopholes are not really loopholes. It's just other ways, more market-based, to develop these intermediaries, brokers, whatever. We will just work on developing one very comprehensive way to do it based on very strict rules. Maybe that's why there are the loopholes. Maybe it's by design that they are not loopholes. They are just alternative systems where you don't have such a heavy regulation from the EU.